Hello, hello, hello. This is Attorney Mark Gravel coming to you from Chicago as usual, and she's back. The Who's Your Daddy lady. I don't want to say her name, despite the fact that she's gone to the press with this situation. I don't want to say her name, although it does come up. It does come up in her court hearing. She says it multiple times. All right, here we go. We're back. We're back with this situation. I just got it from Spike. Thank you to Spike who put it in my Discord. Again, it's from Schnitzel Ninja. I put a link to Schnitzel Ninja's channel in the description below. I just like saying it. I do. And I've got a little warm up. I've got a little warm up that I was working on before this, so I didn't know, but I think it's a perfect warm up for it. It's the warm up is Natalie D's fault and a little bit Kristen's fault. It's fantastic. We got a SovCit. We've got a jailhouse lawyer. And then we've got this woman who claims that Clayton Echard is the father of her twin babies. And there's some stuff going on here. I believe it's the same hearing. I'm not sure, although a different day. I believe it's the beginning of the hearing that we already saw. So while it's called Who's Your Daddy 2, really it's Who's Your Daddy 1, but I can't. You see what I'm dealing with. You see what I'm dealing with here. But we get to hear Clayton speak, and she stands up. So let's do it, shall we?
Moment the clerk's going to find your name and send you an invite, and it's going to show up on your screen. Oh, she got it. Now 14. Who does 14 need to eat with?
Your Honor, that
Yes,
was mine.
that's
I have a motion on that one. Yes.
All right. And then we need a hearing on Miss Smith. So let's, Miss Williams, I would like to have a hearing in your case. If you could unmute and turn on your video so I can place you under oath, please. Raise your right hand for me, please, Miss Williams. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. Now let me get that case in front of me, Miss Crookshank, so I can see the complaint that was filed. Complaints in dispossessory court, Miss Williams, are filed under oath. That means whoever filled out this paperwork swore that it was the truth when they said what was owed. So it's considered evidence in a dispossessory case. Go ahead, Ms. Crookshank.
Your Honor, this is a motion for a judgment on the pleadings. The answer only states that she's tendered payment in the form of whatever document she provided. It's similar to what I think we have referred to in the past as sovereign citizens. Pursuant to the affidavit, we are currently seeking a total of $1,955.94, which is rent prorated through the 18th. It includes a partial amount, $995 from November, $145 in late fees as the monthly, and then utilities of $64 and $751.94 for December.
And your total again was?
$1,955.94, and we are seeking judgment in that amount and a writ of possession to issue in 7 days.
All right, let me look at your answer, Miss Williams, and then I want to hear from you. All right, go ahead, Miss Williams, and explain to me why the landlord's case should be thrown out.
Yes, Your Honor. I have already tendered payment according to the law.
Okay, how did you do that?
I tender payment. I set my documents notarized, and my documents that I sent in to the court and also to the attorney, it's self-explanatory.
Well,
but I've already tendered payment according to the law.
Okay, I need to understand how you tendered payment. Did you give them certified funds, a money order, cash, a payment in the portal?
I've tendered payment according to the law.
Okay, well, You have not established to me that you have paid, so I will issue judgment in favor of the landlord. A writ will
Well,
issue December the 18th at midnight, and the monetary judgment is $1,955.
Your Honor, Your Honor,
That's the order of this
I-
court. You may be excused, Ms. Williams.
I object, Your Honor. I object,
And you
Your
can
Honor.
appeal.
The plaintiff have not filed a motion to pay rent into the court.
You can appeal. I have made my order. You may appeal. It's called a petition for review. The order will be filed by Wednesday close of business, and then you can submit a petition for review if you believe I've made an error. Thank you, Ms. Williams. You can sign out.
Thank you, Your Honor.
That
is my last case, Your Honor. May I be excused?
Yes, ma'am. You're excused.
Thank you.
All right.
Boy, I'm just getting railroaded here.
Thank you, Your Honor.
Yeah, thank you. So
Oh, this is our guy. I streamed earlier today. He was on here. It's the same guy. He's a vibe. He's back, and he's up to his usual stuff.
So to the individual in the jail, is your name James Radsvik? Is that you?
Yes, sir, that's correct. And I've been beaten again this morning. See my arms? I've been tortured, beaten. I need to get out of here, Your Honor. Look at this.
Well, okay. So have you talked to your attorney, Mr. Johnson, recently, sir?
No, I don't know what's going on with him. I can do myself. I'm a jailhouse lawyer. I know the law.
Well, I think for right now, maybe you should stick with Mr. Johnson. But he's filed an appearance for you, sir, so we'll have to wait until he gets here. Sounds like we'll have to put the two of you in a private virtual breakout room to talk about all of your issues. So just be patient. He should be here pretty soon.
Your Honor, if I may say, I filed.
Sir, I don't think you should say anything till Mr. Johnson gets here, okay?
Oh, yes, sir. I apologize. Thank you, Your Honor.
Yeah, so we'll mute the jail. There we go.
Okay, that being no.
All right, we'll start again. Sorry.
All right, here we are.
I'm Commissioner Joe Kestis. We're here in the matter of Clayton Echard. Am I saying that right now? Echard, sorry, versus Laura Owens. This is CV 20230533952. We'll begin by having everyone state their name. Mr. Echard, if you can state your name for me.
Clayton Echard.
All right, counsel?
Yes, Your Honor. Attorney Joshua Lopez representing Laura Owens, who's present via Microsoft Teams.
Thank you, Ms. Owens. If you can state your name for me.
Laura Owens.
All right, thank you. We're here today regarding the pre-issuance hearing on a petition for an injunction against harassment that was filed by Mr. Echard. And so we have an hour and a half for the hearing. That means each side has about 40 minutes to conduct their case and their testimony. So you do want to make sure you're being conscientious of what you want to present in the time that you have available. We do have a number of exhibits. And so if you would like to use an exhibit or admit an exhibit, then you do need to lay some, what I'm going to call foundation for that exhibit, which means you need to tell the court what the exhibit is, if there's a specific date and time that relates to that exhibit, how you have knowledge of the exhibit, and how it's relevant to what we're doing. And then you need to actually move to admit the exhibit. If you want to present an exhibit, you have to, once you've laid that foundation, you have to actually move to the court to ask to admit the exhibit. Just because you submitted them doesn't mean they come into evidence unless you move to admit those, okay? And then
apparently this was before Clayton was represented. I don't know. I'm like watching this as we go. I haven't seen all of this, but that's my understanding.
You'll have the opportunity. So, Echard, you're going to go first because you're the plaintiff. You'll present your case and your testimony, and then the other side counsel will have the opportunity to question you, and then they can call witnesses, and you'll have an opportunity to question them. And then at the end, everyone will have an opportunity to make a closing argument. Okay. The things that people can testify about, you do need to make sure that they are related to something that you have personal knowledge of So you can't just say, I saw something on the internet, and so now I can testify about it. Okay, it does need to be something that you have some personal knowledge about. And I know that this case also has a family court matter. This is not the family court case. This is not the trial on the family court issues. So I
She does show the belly later. You guys tell me what you think.
need everyone to focus on the issues that we have for this hearing. So we're not deciding pregnancy issues, we're not deciding paternity issues. Those are not the issues that are going to be decided today. So what this court is looking for is a determination as to whether or not there were a series of events that were aimed at a particular person that would cause a reasonable person to be annoyed, alarmed, or harassed, that person was in fact alarmed, annoyed, or harassed, and that those actions had no legitimate purpose.
I'm annoyed.
Those are the findings that the court is looking to make. So
That's a pretty low
for you,
bar.
you're trying to show by preponderance of the evidence that that was the case. And then obviously Ms. Owens is going to be trying to show that there is not a basis for the injunction. So the things that are outlined in the petition are the things that can be discussed or addressed. Okay? But as I said, we're not discussing whether or not officially.
I think this said October 23rd. Don't quote me on that, but I think that's what it said on the video.
That there's a pregnancy or whether or not officially there is a paternity issue. Okay? So we need to make sure that we are keeping on track with what we want to show in our case. And so the series of events does need to be more than one, but it can be over any period of time. So those are the things that we're looking for. Does anyone have any questions about what I've just gone over?
Your Honor, I have a couple questions.
Okay.
Did you want to hear opening statements?
I mean, I would allow people to do an opening if you wanted to, or you can waive openings either way.
Okay. And my other question is that what I believe that Mr. Echard is going to present are emails regarding alleged harassment in this matter. But the emails, and I know you had indicated that, and I understand this is not the family law, the family court case, but the emails and the alleged harassment have a lot to do with paternity and things of that matter. So I think that those things are going to come out despite this not being us trying to prove paternity and things like that. I think the content of the emails has to do with that, and so those things will come out.
And I understand as they relate to the specific basis for the communication,
Okay.
that they can be brought out. I just don't want the parties to think that I'm going to be making any determinations as it relates to those other issues.
Thank you.
So do either party wish to make an opening statement?
No.
Or we can just begin with the testimony?
Present my evidence.
Your Honor, I'd like to make an opening statement.
Okay, go ahead.
Your Honor, you're going to hear that back in May of 2023, Laura Owens and Clayton Echard became intimate, which led to my client becoming pregnant with twins. And since May of 2023, Clayton has refused to believe that my client became pregnant. He's refused to believe that he's the father of these unborn children. And he has refused to work.
I too refuse to believe these things. She might be able to prove them, but from what I've seen so far, I refuse to believe these.
Work with my client to create a plan on how and if he wants to be a part of these future children's lives. Instead, Clayton turned to the internet. He's turned to his fans. He's turned to his followers, and he's spread rumors and lies about my client. Clayton has insinuated that my client lied about being pregnant.
I wonder.
Clayton posted online about legal issues he knew little about regarding my client, Laura Owens, and a legal battle that she was involved with and is still involved with another individual. Clayton has posted about Laura that has led to harassment by his fans and followers. Laura has received harassing messages. Laura was asked to kill herself, and Laura has been staying inside to protect herself, which is why she's currently appearing via Microsoft Teams for this particular proceeding. And again, this all stems from Mr. Echard's post online. All communication from Laura to Clayton during these time periods that Mr. Echard put in his petition has been related to Laura's pregnancy with Mr. Echard's unborn children. It's also been related to what Mr. Echard would like to do moving forward with the unborn children, creating a parenting plan, and actually it's also in regard to potentially him taking down posts, which again led to harassment by his fans and followers. None of the communication that Laura directed at Clayton was for harassment purposes. All the communication was for legitimate purposes, and a reasonable person in those same circumstances would not be seriously alarmed, annoyed, or harassed by that communication. And at the end of this hearing, we're going to request that the injunction against harassment be dismissed or not issued. Thank you.
So for testimony purposes, Mr. Echard, I'm assuming you're going to be testifying, and then Ms. Owens, I'm assuming, is testifying, counsel.
Ms. Owens will be testifying, Your Honor.
Okay, so if I can have you both raise your right hands, you can be sworn in for me.
Promise swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Yes.
You? Okay. All right. Mr. Echard, if you want to go ahead and begin with your presentation of your testimony.
Thank you. I think it is important to just provide a little bit of context for that opening statement. It is what he had stated. I do not believe that Laura is pregnant. I know we're not here to discuss that today, but because of the evidence I will present, I'll explain why I've been receiving unwanted messages for the last 5 months, and I have blocked this individual from all communication, yet they continue to send me messages. And I have asked this individual to early on do a paternity test, and she said she would not do it unless I were to date her exclusively. And so then Ms. Owens threatened to go public, which I have submitted that evidence today. But my reasoning for why I doubt her and why I have chosen to cut off all communication is because if I can submit Exhibit 32.
And what is Exhibit 32?
So Exhibit 32 is an ultrasound image that I was sent via email by Laura. No ultrasound report was provided, and when I asked to speak with a doctor, she would not allow me to talk to that doctor. We also did an early resolution conference. It was in the last couple weeks. The mediator asked for her to make that phone call to that facility to prove that she and Dave had to do this ultrasound. She did not do it. She was not willing to make that phone call. And so with that picture and that picture alone, I believe it is photoshopped, and there is no report that she has been able to provide. And I've asked for it, and I would like a doctor to be able to stand behind that image, as I believe it's a fraudulent medical record that she has submitted to me via email.
Okay. Are you moving to admit Exhibit 32?
I would like to admit, yes, Exhibit 32.
Any objection?
Yes, Your Honor. If I'm not mistaken,
I mean, this is beside the point, but honestly, I think he did a pretty darn good job for representing himself. He stayed on point. He's measured. It's one of the better pro se performances I've seen. I'm being honest.
Exhibit 32. You know what? Actually, Your Honor, I'm not going to object to this.
All right. 32 will be admitted.
Thank you.
That's a concern.
May I continue?
Okay.
I would also like to admit Exhibit 36.
Before we get too much further, if you can just explain to me what you believe your relationship is or was with Miss Owens, because part of the reason it's an injunction is because of the relationship nature of it. I think that you listed as being not an intimate relationship. So I guess maybe if you can clarify that for me.
Yes, Your Honor. Laura and I had engaged in oral sex one time. And to me, as I filed this, I did not believe that constituted a relationship of any kind, as it was a one-time thing.
Okay, thank you.
It constituted a wham bam thank you, ma'am. as we like to call it. I don't even like being on here. I'm afraid the accusations are going to come my way, even though I got in front of it.
Right, go ahead, sorry.
Exhibit 36, I would like to admit that as well. This is a flash drive file. This was also sent to me by Laura Owens via email. She, in this email, which I actually have, can I submit multiple at one time or no? Or reference them at least for now?
Okay.
So Exhibit 18 is a screenshot of the email that she had sent me with this ultrasound video that she claimed was, like you can see on there, I don't know, 1,000,000% real ultrasound video. She's claiming that that was the ultrasound of our children. But then I uncovered the Exhibit 34. This is a YouTube video from over 6 years ago, and that video has the video that she sent me within it. And so Exhibit 36 is the video that she sent me, and then the video on YouTube. And as you play both of them out, you can see that they are identical videos. She had cut a portion from the YouTube video and claimed it to be her own when it was somebody else's. And so I would like to, I'd like to admit at least Exhibit 36, but also 34 and 18 to prove that she did in fact send this to me via email, and as 18 and 34 show, but also then to admit 36 because that is the visual proof that these videos are identical.
Any objection to 18?
Yes, Your Honor. I don't think there's enough foundation for the different things that Mr. Echard is stating. It sounds like something was sent to him, and I don't know what websites that he's going to get these. And the things that he's claiming in here, he's saying that these are identical. I don't know if he can testify that these are in fact identical.
Okay. So 18 appears to be kind of a screenshot of almost similar to 32, but I think it's closer to matches the 34. But I think 18 is the one that actually was sent to him. Is that correct?
That is correct.
So do you have a specific objection to 18? Or objection?
If that's what was sent
more related.
Yeah. Wait, 17, 18.
18, I think, was the one that was sent to him. So do you have something specific about that exhibit?
I mean, maybe just some foundation regarding who it was sent from and how he knows. Your Honor.
So, Mr. Echard, if you can just outline for the court specifically the way that you received this.
Yes, I was sent this by Laura Owens. As you can see in the screenshot, this was sent from her.
What date?
The date of it was October 6th at 4:39 p.m.
Any objection to 18?
Your Honor.
18 will be admitted. And then 34, give me more information about when and where you received this document.
So Exhibit 34, I uncovered as I had questioned the validity of Exhibit 18, what she sent me. I did not believe that it was in her ultrasound. So I started to look online and I found this YouTube video. And upon playing it, I found that the video that she had sent to me is within that YouTube video.
Okay. Objections to 34.
There you are.
34 will be admitted. And then objections to 36.
There you are.
Right, so 36 will be admitted. Record, if you want to continue.
Yes, I would like to. I would also like to discuss Exhibit 30. So Exhibit 30 entails a prior court case with this individual. And the reason why I bring it up is because of the repeated or similar patterns of behavior that Ms. Owens has exhibited. In this exhibit, there is an ultrasound in which she presented to this individual, and then it was found that through a reverse Google image search that she had taken that from online as well. In this case as well, she states that she became pregnant by this individual, and she also claims that she was became pregnant with twins after one sexual encounter. And so the parallels between my case and this individual's case, I think, is important to bring that to light and admit that as well, because this individual has displayed repeated patterns of behavior. And I think that's important to note as to why I question the validity of this individual's claims.
And where did you obtain this document?
I obtained this document from this court. I came in here, it's publicly accessible. So I came here and I searched it, and there's about 14 pages in this that I printed off. There's more in the court system, but I consolidated it to bring out the documents that referenced similar instances. And so this individual that she had brought this claim against also questioned if she was pregnant or not. It does state in here that she provided sonographic images, and then a reverse Google image search revealed the images were identical to a sonogram found on a blog post from 2015. And then within this document, it shows the pictures that were submitted to the court, the ultrasound in question. And then I'd also like to bring to, in this document, in the picture, it says that she'd sent to him, it looks like you're going to be a dad to 1 or 2 babies. And so she again states that she was pregnant with twins with this individual. And then on one of the last pages of this document that I had pulled out, it was noted in this court case, the plaintiff reportedly fabricated a pregnancy and subsequent abortion in the past during a relationship with a Michael Maricini in 2016. I do not know the specifics of all of these cases, but I do want to bring this to light and submit it admit the exhibit because of the repeated patterns of behavior that I think are important to note, because contextually speaking, that is part of the reason why I will then present my evidence towards why I feel I'm harassed, because I do not believe what this individual is stating. I don't believe anything that she's saying, and these are the reasons why.
Your Honor, I'm going to object to this being entered. This is an ongoing case. We don't know what claims are or are not true within this exhibit. I don't think that it's appropriate, and I don't think that it's relevant to Mr. Echard's petition in this specific matter.
So one of the allegations is a pattern of behavior of accusing men of getting pregnant in his petition. So I guess that's what he's presenting it for. So hang on, Ms. Owens, just a minute. I think that's one of the allegations in his petition, but
again, Your Honor, this is an ongoing case. We don't know what the results of this specific case regarding this exhibit We don't know anything about this case. We have it looks like this is some sort of complaint. It looks like it's a motion to dismiss, I'm sorry. Or there's several documents here. I don't think that this is relevant for this particular case. I think that this is speculation. These are claims that other people have made. I think this is hearsay. I don't think it's admissible for this type of hearing.
All right. So I'm not going to be able to admit Exhibit 30. I do agree that there's not, this is a complaint and a motion to dismiss, but whether or not there's significant information enough to be able to support that and whether you have any knowledge of it is I think I'm not going to be able to admit that exhibit. Ms. Owens is raising her hand, but your attorney is here. So did you have a question?
No, he covered everything.
Okay. And he's going to be speaking on your behalf unless you're testifying. So
I would like to testify.
You don't have your chance to testify, but you can't testify in the middle of his testimony, and then your attorney needs to be the one that speaks on your behalf unless it's your testimony, okay?
Okay.
All right, Ms. Echard, anything else?
Yes. Now I'd like to go in and admit each of these documents, and I have them set in an order. So the very first one, Exhibit 1, this is just showing all of the files that I have accrued. There's often 2 to 3 emails that she sends me a day. She started sending me emails, harassing emails on the 6th of June, and she is still sending me emails as of yesterday. And so Exhibit 1 is just showing the frequency of her harassment from a bird's eye view.
And so when you get the email from her,
I believe it. I got annoying emails from her too.
tell me how this gets created.
Yes, so when she sends me emails, I screenshot them and then I place them into these files so that I have them for a record.
Okay. Any objection to Exhibit 1?
Yes, Your Honor. Again, I don't think that the frequency of emails is something that would indicate harassment without something more. If there's communication back and forth between emails.
I agree. The contents are annoying as hell and they're frequent. That'll get you over the hump right there.
Then the frequency of how many times somebody sends an email, I might send 60 a day, but the frequency of emails.
I got like 3 from her, and I never want to hear from her again. I'm saying that was enough for me.
Between, I believe, May to now, and I don't know how many these are. We don't see the emails in here. There's nothing to say that this, in fact, is harassment within the meaning of the statute. So for those reasons, I'm objecting to this being admitted.
All right. Over the objection, I'll admit Exhibit 1.
Admittedly, maybe more, but I don't check my email for just this reason.
Thank you. Can I continue? Exhibit 2, a lot of these next exhibits are all going to be phone numbers that Laura has contacted me from. She has contacted me from 13 different phone numbers, and I finally stopped blocking them.
That's not psycho at all. She just likes to vary her telecommunication devices.
13th one because I knew that she just would continue to create a Google Voice phone number. And so this first one, it says in the text message, it's Laura, and please unblock and then she shows her number. That was her original number. And so I would like to admit these one by one to show again the many different times that she has continually contacted me after blocking her from different phone numbers.
And so this is a text message from when? Do you know?
Unfortunately, I don't. It just says text message from today. Again, I was screenshotting these as I received them. I received these over the last 5 months. As far as what exact day, I'm not right now. I'm not aware, and I don't know if there's.
Can you approximate when this message came in, or you don't know?
To be honest with you, Your Honor, as far as when this one came in versus the other ones, I don't know. This one says, I have it down here as her blocked cell number 12, so this is probably one of her last ones that she had sent to me. And I would say that I think this one came through probably about a month ago, because since then she resorted back to sending me emails because she put a mail tracker on the messages. So she was able to see when I was reading them. But during this period of time, when she was sending these text messages, I was not opening her messages. And so she knew through her mail tracker that I wasn't reading them. So she decided to go about the Google Voice manner in order to get them to me, because she could see that I was not opening her emails.
Okay, so you have this one, you believe is from one of the 12, at least the 12th message, that as well as cell phone number that she was using.
Correct, yes. Each of these came from Laura, yes.
Okay. Any objection to 2?
Yes, Your Honor. Again, Mr. Echard must show that there is harassment.
I did give a dramatic reading to her emails. It's in a prior video. I can't remember which one off the top of my head, but it's in there. 3 or 4 back.
And when I look at this text message, I don't see anything that is even remotely close to harassing here. It's a text message indicating to him that they're having a boy and girl. She has an ultrasound to show. I just don't see anything in here that is even related to the petition itself that shows that this is harassment, that he is annoyed, alarmed, harassed in any way. This is simply a text message.
Well, I mean, part of his, petition is the high volume of those, and that ultimately he can testify whether he was annoyed or harassed by these. So I'm going to admit Exhibit 2 over the objection.
Thank you. Again, Exhibit 3, just to make this, again, I want to be respectful of everyone's time here. This is, again, another cell phone that she had contacted me from, so I'd like to admit this one as well for the same reasons as Exhibit 2.
Your Honor, it sounds like there's going to be a number of different cell phone screenshots submitted to the court, and I just want to make record straight that I am objecting to all of these based on the same reasons I was objecting in Exhibit 2. So,
okay. So
I don't have to just repeat myself over and over again.
All right. And so, this Exhibit 3, it has that similar language to please and block the original number. So you're telling me this came from Laura, but from another blocked number.
Correct.
All right. I'll admit 3 over the objection.
Thank you. 4, also sent from Laura. This one says that she couldn't get into Google Voice, had to make a new number. So again, this one just shows that she wasn't back to using Google Voice and creating more and more numbers in order to harass me. And yes, I did feel harassed because I did not want these messages. This one you can see I did respond to, and what I said is how I felt. I was asking for her to schedule the paternity test, which she continuously declined unless I were to date her exclusively. But for the purposes of this text message, it was another unwanted text message that she had sent my way.
So tell me a little bit more about the dating thing, what you're telling me when you say that.
Yes, so you can see this in this exhibit here. She said, guessing you won't read this, but I made you a pretty good offer. Meet up tonight to discuss the pregnancy and the possibility of dating. But regardless of the outcome, I will schedule a test with Rabjin tomorrow. So her stipulation for taking a paternity test early on has always been that she would only do the test if I were to date her exclusively for 2 weeks. Then she dropped it to a week, and I did not agree to any of that. I simply just said, as it says in here, drop the dating stipulation, schedule the test, pay for the first part of it, then email me when you schedule it, and I will schedule my part. So I had continuously tried to figure this out, and she would not do the prenatal paternity.
I share your concerns, but I think that this one is verifiable. Even a court with sympathy to it can't get around that.
Paternity test unless I were to date her.
And this Rabjin is
it is the facility that provided the test so that you can test for a prenatal paternity test for twins.
Okay. All right, I'll admit 4 over the objection.
Now I get it. It's just his testimony, and I don't know if she agrees with that or not because I haven't gotten there. But if what he is saying is true, and this guy seems to make a lot of sense, it seems reasonable to me. That is absolutely insane. I will take a pregnancy test if and only if you date me. Wow.
5, again, is another text message. From her again, saying that she doesn't know how to use this app. She's referencing Google Voice. She said, I'd like to meet, no strings attached. I did not want to meet with her. She's asked me to do multiple times. I do not feel safe meeting with her because I'm not sure what she would claim if we were to meet up.
Bingo.
I don't have any reason to meet up with her. So this is another text message that she sent me that was unwanted and very harassing.
I mean, seriously. Once you find out a BJ isn't safe, you're shaking, you know? You're shaking at that point to the core. She might hold him hostage. She might take him and force him to watch like a Lifetime Christmas movie with him or something.
Over the objection, I'll admit 5.
6, again, another text message says she should change her number. I would like to admit this one as well for the same reasons as the previous messages.
All right, and this is another different number than previously used.
Yes, and then in this one, I would even just like to highlight, she said she threatened to leak this to the media, which I will be admitting my evidence for that, but she threatened to go to the media, which she ended up doing.
Actually, you're right. I forgot. Yes, at the end of the hearing, on the first video I did, he did get a favorable ruling.
This text message just proves that she was again looking to defame me through basically whether we date or leak this to the media. She threatened me to go to the media with this text message, amongst other times she threatened me.
All right, I'll admit 6 over the objection.
7, similar thing again. She stated this time she would do it with no strings attached. I had then responded by saying, let's schedule the paternity test regardless. But she was asking for this agreement and that we needed to meet up for a good faith consultation. Again, I did not feel safe meeting up with her one-on-one, so I disagreed with this. But this is another text message that she decided to send from a different number. These are all, as I can just a reference, these are every single one of these, as you can see at the top, they're all different numbers. So these are all coming from a different number every time.
I'll admit 7 over the objection.
Another text message, she just states that she sent an email to Rabjan, and then she threatened, you want me to go to the public instead of meet up? So those were the options. Either we meet up or she goes public with the information.
I'll admit 8 over the objection.
Leave me alone.
9, another message that I didn't block. As you can see, she sent multiple messages before I decided to block her. And she was asking for a good faith consultation. Again, she was trying to meet up with me. For what reason, I can only speculate, but I did not feel comfortable doing so. And so this is another phone number that I ended up blocking.
Oh yeah, she did not pick up how annoyed the judge was when she's like, "You have your hand up," and then when she cleared the issue that there wasn't one, she didn't say take it down, which I would have, and this one didn't pick it up. It's fun.
And can you elaborate on what it says? I just made what I think is a very enticing offer. What that mean?
So to be honest with you, I don't remember exactly what her offer was. She made multiple ones, but they all centered around a very similar, if we meet up and we try to date, it was 2 weeks, and it became 1 week, then it became just meet up for this tonight, this good faith consultation. And she would make a lot of promises as far as once we do this, then I will go take the test. But again, I did not feel safe being with her one-on-one. I did ask actually to meet up with the court in the court, or I said we could even meet up. At one point, I said a coffee shop with people around, and she declined that and said, no, we need to meet up in private. So I said no to that, and blocked her again on this phone number.
All right, I'll admit 9 over the objection.
Again, 10, this is another phone number. She mentions going dark on her, which is a reference to me not responding to her. Again, just to highlight that she has been consistently harassing me with me not responding to her for the large majority of these messages. The only time that I was often responding was to try to get a paternity test scheduled. Outside of that, I did not. I had little to no interaction with her. And so at this point, she references here, I will cancel the Rabgen appointment. She had scheduled one, paid the $750 for it. But then in the past, as she had stated she had scheduled it, she would end up canceling these. So it was just a show on her side of things to state, yes, I'm trying to do this test. But when it came down to it, she always placed stipulations whenever I responded to her. So at this point, when she said I'd spend $750, I did not respond to this and blocked this phone number because I was not taking any of what she was saying seriously. Because every time I would ask, okay, let's do this, she would bring a stipulation on board.
Submit 10 over the objection.
11. So again, similar thing. I think this is around the same time. She said she'll tell Rabgen that we don't want the appointment next week. But I couldn't be more steadfast in my decision not to take it early without the stipulation. So again, the stipulation is the only way, as she says here, and then she says, anyway, I hate to go to the press, but that was your decision as well, and I respect it. And then she even says, she tries to talk about making an offer on a property for real estate, but so again, I don't understand why, as clearly there's no relationship here or any interest in me wanting to talk, but yet she was trying to have any type of discussion with me. But again, she says here stipulation is the only way to do the test, and so I end up blocking her again.
That was mid 11 over objection.
12, again, this one, she said she wants to do the test. I then said, you want to do the test and the stipulations? She said, you're going to be forced by the court to meet up with me. So the second I found out that she, again, I asked, she'd do no stipulation. She ended up saying, you have to meet up with me. And then she says down here, I said, you're willing to meet up in a very public place. You will take the test afterwards. She said, no, it's with a week worth of stipulations and hopefully more. So again, she stated that after she said she wants to take the test, she then confirmed that she was not willing to take the test unless the stipulations were added.
I'll admit 12 over the objection.
13. Again, another message from Laura, different number. I asked her if she'll meet up with the court with the mediator present. She said that's not how it goes. We can meet up just us, and I will withdraw the request for sanctions. And then again, I said, would you meet up in a public location? This thing was cut off. It was in another text message, but she ended up disagreeing to or not being willing to meet publicly. She said we had to meet privately, and so then I blocked her on this phone number as well.
I'll admit 13 over the objection.
Okay. How am I doing on time?
You have about 10 minutes.
That's okay.
Maybe 15 minutes.
I want to skip now. I want to make sure I get to the ones that I really want to talk about.
Mm-hmm.
Okay, so Exhibit 15. Laura sent me a very alarming message stating that she was going to kill herself if I do not remove it was a video that I posted to my Instagram. So Laura has claimed that my responses online are meant to defame her, but that is not the case. Laura decided to leak this story to The Sun originally, and she leaked it with her anonymously, so she did not place her name out there. But what she did do is she mentioned to them that we had an active court case. So that active court case, she is the one that brought that against me. In that court case, her name was on the court documents. So she ended up then bringing that, once this was leaked to The Sun, they submitted the story, And then it stated that within that document that there was an active court case with me. People then searched my name and found her name through that. So this email right here, she was basically threatening me to take down my video. In my video, I just stated that this individual was making these claims. I just made a statement of the facts, so they were making these claims, and they opened a court case against me. And then from there, I do have a large following. I am a public figure, a celebrity, I suppose. I don't like that word. But I have a large following, and then that audience, I cannot control what they do. But they then went and found that court case in the system and found her name and then started to talk about her online. And then Laura, I assume, was feeling the pressure from it being online and her name being out there. She then sends me this alarming message, which again I felt was harassing, but to threaten to kill herself. I don't think anybody should ever receive a message such as that.
All right.
Your Honor, I'm going to continue to object for the same reasons that the other exhibits 2 through 11, actually 2 through 13, for the same reasons. I don't think that, again, this is showing that this is harassment by sending an email to him, asking him to take down posts or saying that maybe she is suicidal. And for those reasons, I'm requesting that this not be admitted into evidence.
All right. I'll admit 15 over the objection.
Thank you.
The standard, I object because it makes my client look bad.
Come back to that. Let's see, I just want to make sure if I have some run out of time here. I'll jump ahead here just to Exhibit 23. So Laura has contacted multiple nonprofits that I work for in attempts to defame me and basically get them to not work with me. So in this email here, she sent this to the Arizona SPC. This was I just spoke actually at this HOPE conference. I'm a mental health advocate. And so Laura began to blackmail me and reach out to individuals that she had seen that I interacted with online. So I'd like to admit this as evidence that, again, she was harassing me through reaching out to individuals close to me in attempts to defame me.
And how did you get this? It was sent to you as well?
She copied me on email.
Okay, and when was this sent?
This was sent on August 3rd, 2023.
Okay. Any objection?
Yes, Your Honor, I'm going to object because this appears to be an email that Mr. Echard was either to or CC'd on that indicates Laura's reasoning for why she believed that he shouldn't be a speaker at this conference. Again, this isn't harassment, and it doesn't seem like it was directed toward him. It was directed, although he was CC'd in the email, or he was in the email, it was directed to the HOPE conference in relation to whether he should be speaking at this based on what was going on and his credibility. I don't think this would be appropriate to be admitted in this case. This wasn't directed toward him for harassment purposes, and so this shouldn't be admitted.
All right. I'm going to admit 23 over the objection.
I would like to now go to Exhibit 26. This email was sent by Laura threatening to sue me, again, with the videos that I was posting in order to protect my own image. My image is how I make my money, and I make my money online, mental health advocate. Also, being a public figure, I have brand deals and such and companies that I work with. So everything that I'd stated, I've never once mentioned her name in public. And then in this email, as I put up a video to protect my own integrity and protect my own reputation, Laura threatened to sue me with a massive lawsuit and stated she had an unlimited budget to sue me, which I felt was very harassing in nature.
Is this the same video that was the previous nature of the other email that she was asking to take down? Or is it something?
I believe this one was. To be honest with you, again, I put up a few messages or videos. I believe that was referencing that video, where again I believe it was either that, but to be honest with you, I'm not sure if it was that one or if it was the one where I stated I had scheduled.
Yeah, somewhat. I think I saw a thing that said that he was in an NFL camp, which is damn good. I know he walked on in college, so he played football at a very high level. I don't know that he had any grand NFL career, but he even being in camp, that's damn good. And then he was a contestant on The Bachelor, so yeah, not super famous, but some level of notoriety for sure.
A prenatal paternity test, and I was waiting for her to schedule her portion. I submitted I think I put 3 or 4 public statements online, and every time she had threatened me to take it down or face legal action.
Any objection to 26?
Yes, Your Honor, same thing that I've been objecting for this entire time. I don't think that this email specifically shows that she was trying to harass him. I don't think that is relevant to the petition, and for those reasons, I don't think this should be admitted.
I'll admit 26 over the objection.
Thank you. Anything else? I guess I will go to Exhibit 19 now. This is, again, another email that I was copied on. Laura had sent this to my father. Sent a long email basically saying that I blocked her and that, hopefully he could get through.
Oh, good Lord. That's all I need to hear. He sent an email to his father. I mean, we can get around it, but there's just no way that's appropriate.
To me, get me to end up talking with her. So I want to admit this just to show that she went to many various different avenues, friends and family, in order to bring light to this and put pressure on me to then interact with her.
Different objection to 19.
This isn't directed at Clayton, Your Honor. This is directed at his father. It's an email to his father. Mr. Echard's father is not indicated in this petition. He's not here today. I don't think that this should be admitted for those reasons.
It does appear that Mr. Echard was copied on the email as well, so I'm going to admit 19 over the objection.
Thank you. I'd like to look at
About 5 more minutes.
Okay, thank you. I'd like to look at Exhibit 16. This was an email sent to me from Laura, and basically in this is Exhibit 16 and 17. They came within the same email. She stated that this is the photo I'm going to use. It was a picture of 2 pieces of clothing saying Echard twins coming February 2024. In this email, she said, "Surprise! I can't wait for the arrival of these 2 next Valentine's Day," which I don't know how she would, know that she'd be due on February 14th. But she stated then that on a more serious note, their father said he wants nothing to do with the process. He has blocked me. Tag him and let him know what you think. So this was a threatening email where she was stating, if you want option A, and option A had to deal with dating her. She said, "I will not post this. I'm just looking for support during this incredibly overwhelming time."
And when was this sent?
I see that it says yesterday, 2:23. So I wish there was a timestamp, but I believe this was earlier. This was probably 3 months ago. It was towards the beginning. Again, this has been 5 months ongoing, but this is probably 3 months. And at this point, this is before she had not leaked the story to the Sun at this point.
Any other objection to 16 or 17?
Objections to both for the same reasons stated before, Your Honor.
All right. I'll admit 16 and 17.
Thank you. I'd like to focus on Exhibit 21. So this shows a process server that Ms. Owens hired to serve me papers when I went down to Miami to visit my cousin. She knew that I was down there, and she had researched women that I had interacted with or expressed interest with in the past found that these two women lived in Miami. I didn't even know that Mrs. Jessica Echard even lived in Miami, but I did not go to see either of them. But she had a process server try to serve papers to both of those residents, which I felt was very harassing in nature, as these individuals I have not been in contact with for quite some time, and I believe it was a display of power on Ms. Owens' part to, again, harass me and try to get other people involved. And so I'd like to admit this because I felt that, again, it was very harassing in nature that I had a process server trying to serve papers to individuals that I expressed interest to in the past. It didn't seem necessary, as you could have just served the papers in Scottsdale.
Yes, Your Honor. In almost any lawsuit, there needs to be service of process. That's how a lawsuit begins. That is for personal service. The court has jurisdiction over the person. Nobody likes to be served papers. I don't think that this shows any amount of harassment. This was the process server emailing.
Sweet Jesus. I serve people all the time. I'm a plaintiff's attorney. I file suits. I serve people. I have never, ever, that I can think of, tried to serve somebody out of state. After multiple attempts when they're out of state, then I serve them through the Secretary of State. I don't mean to get too into it, but I can't tell you how weird it is on an early attempt to try to serve somebody when they're out of town, especially when you know where they freaking live in town.
Agreed. My client isn't even on this email.
All right, so I'm going to sustain the objection as to Tony 1. I'm not going to admit that one.
I disagree with the ruling. It's not the end of the world, but I disagree with that ruling.
I guess I can just admit this last one. Exhibit 35. This was sent on Friday of last week. I took a screenshot of it. This is after Ms. Owens filed a order of protection against me. And as I've never threatened her, I believe I have not ever threatened her, but yet she continued to contact me. So this was, I thought, again, she was asking to go to a sonogram appointment, and it would mean a lot to me if you would go. Again, I think all things considered, the fact that she's still, I had no interest in wanting to meet up, and she was still sending me these messages after she placed an order of protection against me. I think it just more so shows that the reason she sent an order of protection, it would not make sense as to why she would want to meet up after that point. Again, this felt threatening because just another message that she continued to send. And I just didn't, again, I've been not wanting any of these emails to come over to me.
Any objections?
Yeah, Your Honor, same objections as before, but at the same time, this is outside the scope of even this petition.
And I do think we're restricted to kind of the petition since this was happened after the petition was filed. I will sustain an objection and not admit 35. Record, if there's any other testimony you want to give as well, just outside of exhibits that you want to let the court know, you can also provide other testimony.
Yes. Is this the time for me to ask for a request from the court, or as far as what I don't know?
I'm not sure what that is, but you can.
Again, I guess I'll say this.
And you'll have a time to do a closing, but if you have additional evidence or anything else you want to present.
That's what he means.
That's what I'm looking for you to do. But if you have a specific question, you can ask that as well.
Okay. I guess I just wanted to state, well, maybe this would be better for my closing statement. I guess I don't have any questions at the moment.
Okay. And no other evidence you wanted to present?
I mean, for the sake of time, I know that I ran out. I mean, I could try to submit the rest of these, but I think I've run out of time.
All right. Thank you. Any questions?
Yes, Your Honor. You were Laura's real estate agent, is that correct?
I was for a brief period of time, correct.
Okay. And that was that was earlier this year, is that correct?
Correct.
All right. And back in around May of 2023, you and Laura had become intimate, is that correct?
Correct.
And since then, Laura has made it known to you or has claimed that she's been pregnant. Is that correct?
That's correct.
And you have, even until this day, you've refused to believe that Laura is pregnant. Is that correct?
I would say that's not correct. I mean, I did question, yes, if she was, but I have tried to give her every possible option or ability to prove to me that she's pregnant. She's not allowed me to talk to any of her medical examiners that have administered the quote-unquote ultrasounds that she has done.
Okay, and she isn't required to give you her health information. Is that correct?
I personally would say that when she's claiming I'm the father, that the father of her alleged children should be able to have access to her medical records, especially when it's pertaining to pregnancy.
Ooh, that didn't go well for you, did it?
But it is true that at the beginning, back in maybe May or June, you did not believe that Laura was in fact pregnant. Is that correct?
Yes, I have questioned if she's pregnant.
Okay.
Correct.
You have exchanged emails or text messages with Laura indicating that you did want her to get an abortion. Is that correct?
I had stated that if my preference was to not have children with her, but it was ultimately her choice, and I was not going to pressure her.
And those were communications that you had back and forth with Laura in text messages. Is that correct?
Yes, we had interacted via email early on.
Okay. But had you also interacted with her in text messages?
Yes, as evidence I've submitted, I did respond to her early messages.
Now, you agreed to meet with Laura or have Laura come to your house to do a pregnancy test. Is that correct?
That's correct.
And Laura did come to your house to do, or go to your house to do a pregnancy test, correct?
Yes, she ended up doing one when she was there, yes.
Okay, and that test showed that she was in fact pregnant. Is that correct?
And showed that she had HCG in her blood, yes.
Okay. And when you all agreed to do that, you were communicating back and forth with Laura, correct?
Correct.
She didn't just show up at your house, correct?
Correct.
You questioned then not only whether she was actually pregnant, but then whether you were the father. Is that correct?
That is correct.
And Laura went out of her way to schedule various paternity tests to show that you were the father. Is that correct?
For that, I would say she was claiming she'd scheduled them. She did schedule a few, but then whenever I did not agree to her stipulation, she canceled them.
Okay. So she scheduled a few. Is that correct?
I believe she did, yes.
Okay. And it was her that did the scheduling. Is that correct?
Until I scheduled one, yes, that she and I took recently, which came back little to no fetal DNA present.
Okay. The communication between you and Laura for the scheduling, was that through email?
Yes, mostly it was over email at that point, correct.
Some of it was through text messages, is that correct?
I had asked for her to schedule them via text. Yes, I believe that, yes, I mean, as you saw in the exhibits, I had asked her if she would do it without stipulations.
Okay. And so there was communication back and forth between you and Laura, is that correct?
But yeah, it's very limited overall considering the frequency of the messages she sent. But yes, at certain points I was trying to work this out with her.
Okay. Now, the text messages and emails that you've provided to the court today, those are not all of the text messages from you, and of course they're not all of the text messages from her. Is that correct?
That's correct.
And same thing with the emails. That's not all the emails from her. It's not all the emails from you. Is that correct?
That is correct.
Okay.
I would not be able to submit.
I don't have the question. Now, Laura, you at some points in time stopped responding to Laura, whether it be through text messages or emails. Is that correct?
Yes.
And this is also around the time when Laura was trying to schedule the paternity test. Is that correct?
I stopped responding, and then she started to state she wanted to schedule a test just she was claiming she wanted to, but she would never, whenever it came down to me wanting to schedule it with no stipulations. So I stopped responding at a certain point when I realized that she would always keep adding the stipulations in. From that point forward, she was making claims she wanted to schedule them. It didn't mean anything. She had already proven that she had no interest in actually following through.
Was there a time that you're aware of that Laura hired an attorney to help schedule the paternity testing?
I had spoken with one of her attorneys at one point, and they had shown me the ultrasound that I had admitted here, and I asked for them to subpoena the records or to get the records from that ultrasound. She would not provide it, and then stated that I asked her if she would schedule without stipulations, and the lawyer told me she would not.
Okay. Laura paid for you to have or to do some sort of blood test to determine, to do your part of the paternity testing. Is that correct?
As I referenced in my exhibits, she did make a payment, and then when I would not do it without the stipulations, she canceled.
She canceled or you canceled?
Canceled. Somebody canceled my portion. It was not me. It was I. They called in and tried to cancel my portion, in which case I found that out, and that's what led to me scheduling it and then going online to make a statement so everyone knew that I was trying to do this paternity test. I did not cancel it, though. Absolutely not. Somebody called in and canceled it for me because our names were under the same test.
You're stating that somebody canceled a paternity test on your behalf, and it wasn't you, and you didn't authorize that?
That is correct.
Probably your client.
Now, you and Laura have an active family court case together. Is that correct?
That is correct.
And it was Laura that filed that case against you. Is that correct?
That's correct.
And this family court case is in regard to paternity. Is that correct?
In regard to a parenting plan, she filed for a parenting plan.
Okay.
The children that have not been proven.
All right. And you're not represented by an attorney. Is that correct? In that family court case?
That is correct.
Okay. And is it your understanding that she, at least at the time, wasn't represented by an attorney in that case?
I understand the purpose of that question, but I don't. So I've spoken with lawyers. I believe that she filed in that case, though, as representing herself.
Okay. And the court ordered that you guys meet and confer. Is that correct?
For an early resolution conference virtually, but not to meet in person. That was never sent to me, although she claims that the court mandated that.
To resolve different issues prior to that conference. Is that correct?
The court did not mandate that. I never was told by the court. I was told to show up to an early resolution conference. She said that we were supposed to, if able to. Apparently the court asked that individuals try to resolve all matters, but I had no interest in doing that because I did not trust her if we were to meet up one-on-one, what she would accuse me of.
Okay. But she emailed you or texted you in regard to trying to resolve those issues before showing up to the early resolution conference. Is that correct?
Claim that we needed to meet up to discuss matters. What specifically I was not sure of.
Now, you have accused Laura multiple times of lying that she is pregnant. Is that correct?
That's correct.
And you've done that online. Is that correct?
I believe in a video, again, I never once mentioned her name. I believe I may have said I questioned whether or not she was pregnant.
Okay, so you insinuated that she was lying. Is that correct?
I believe she is lying, yes.
And the different media outlets that have you spoken to media outlets about this?
I early on provided statements to a couple of outlets to state that I did not believe that I was the father, and that I was hoping to do a prenatal paternity test in order to prove whether or not I in fact was.
Okay. And up until recently, you hadn't done a paternity test. Is that correct?
Yes, but that was because of Ms. Owens was not willing to do one as I asked her to as far back as 4 months ago.
Okay, so you're blaming Miss Owens for not doing a paternity test, is that correct?
Correct.
And that's why you wouldn't do a paternity test?
I could not do one because she would not do one. She would not do it unless I were to date her. Those were her stipulations.
I don't get where he's going here. Yeah, to do a test, you got to compare him to her, to the baby, and the baby's in her to the extent you believe there's a baby. He needs her cooperation to do a paternity test. He can't do it alone.
Now, you indicated that you spoke to the media about this, and they published those statements online. Is that correct?
There were a few outlets, yes, that published my response. Yes.
And the results of the paternity test are not resolved. Is that correct?
I was told that little to no fetal DNA was present on the first sample and that she needed to submit another sample.
So the results are not in yet. Is that correct?
Yes, I suppose that is correct.
Now, you had indicated that Laura had blocked you several times. I apologize. You had indicated during your testimony that you had blocked Laura several times from various numbers. Is that correct?
Yes.
Okay. But you were in communication with Laura this entire time since May. Is that correct?
I would not say that's correct. I was not in communication the entire time. If I were to be able to show all of the exhibits, I probably responded to maybe 5% of what she has sent to me.
Okay. I'd like to take a look at Exhibit 4. Plaintiff's Exhibit 4. You had indicated that this was a text message from Laura to you. Is that correct?
Yes.
Okay. And you had responded to Laura in this particular text message. Is that correct?
Correct.
Okay. Is that the same thing with Exhibit 12 and Exhibit 13? You had responded to Laura after she messaged you?
If there's a text bubble, as I'm trying to look here for the sake of respecting time, if there's a text bubble, then yeah, I mean, I was the responder in those messages.
Okay. And in all of these text messages that you submitted to the court, did you ever one time tell Laura to stop texting you?
Multiple times I asked her to stop communicating with me.
Okay. I'm asking in the exhibits you submitted to the court and in your testimony, you have not one time ever said that Laura stop texting me or stop communicating with me, did you?
I'd have to go look back at the exhibits that I directly submitted, but I've asked multiple times for her to cease communication. I know you're asking for me specifically if I stated this in the text messages, but I can absolutely confirm I've asked her multiple times to start responding to me. And I have evidence to prove that, maybe not on these text messages alone, but again, I have 500 exhibits I could have been submitted.
And isn't it true that you indicated Laura threatened to go to the media regarding this, correct?
Yeah.
You had indicated that Laura had spoken to you via email or text message that she was willing to go to the media to discuss what was going on between you and her. Is that correct?
Yeah, she stated she was going to go to the media, yes.
And didn't you email or text Laura indicating, go ahead, essentially, go ahead, you can talk to the media?
I believe I did state that at one point, because my reasoning for that was because I knew she was trying to threaten me and scare me by going to the media, and I did not want to give her the joy or whatever you want to call it of knowing that she was affecting me. So I just stated, sure, if you want to go to the media, go to the media. But I was not giving her permit. I guess I wasn't agreeing to it. I just knew it was inevitable. She was threatening me.
So you consented to it?
I wouldn't say I consented to it. I wanted to resolve this privately very, very early on, multiple times. And as I sent some of these exhibits show, I was trying to, she had threatened to go to the media multiple times. And at that point, after she had threatened me multiple times, I stated, go ahead, just simply because I knew that she was going to continue to threaten me and she would eventually go public.
No further questions.
And you have an opportunity to provide rebuttal testimony if you want to, based on what he asked you. If you have anything else you wanted to help clarify.
Yeah. Again, I think what he's trying or what he's attempting to show is that there was continuous communication throughout. And I believe, again, this is a matter of frequency, my messages versus hers. I was continuously trying to solve this matter. And the few times that I did reach out, I was trying to come to a conclusion. Again, had I actually been the father and the prenatal paternity test was done 4 months ago, I was willing to take the test back then and willing to then move forward from that point. But this individual, Ms. Owens, never had any interest in settling this matter. As I had referenced in our prior cases, this individual, I believe, again, this is just my opinion, but, harasses individuals into dating her. And when they do not want to, then she starts to say that she's not willing to take a test, or at one point it was, I'll take Plan B or the abortion pills if you agree to date. So there's always stipulations around that. But the few times where I did respond to her, it was from me trying to get a prenatal paternity test on the books because I was wanting to be able to prove that I was not, in fact, the father. Through all of this, I just want to make this statement. Ms. Owens has not been able to prove that she is 5 months pregnant with twins. A positive HCG test, you can manipulate HCG levels. These sonograms don't have a report with them either. And so no doctor has ever stood behind these tests and been willing to state that she is in fact pregnant with 5 months pregnant with twins. And so
No, I'm going to object right now. This sounds like a closing argument as opposed to testimony.
Overruled. Go ahead.
So the whole thing for me is I've been trying to quash this. I've been trying to come to a solution. I never wanted this to be public. I never wanted this to get out there and be such a big deal, but this individual did and made sure that it got out. I would just, I would like the order of protection or injunction against harassment. I would like that because this individual is an aggressor, and if she will not continue to come after me, or she will continue to come after me unless I cut off communication. And so this is whether or not I responded, it's the sheer frequency of unwanted messages that she sent me.
Tell me what that is. Tell me what you believe is the number of messages you've received.
I believe in that I believe she has sent me at this point 400 to 500 emails, probably.
That's over what period of time?
Over 5 months.
And is that including email and text messages, or?
Yes,
email?
She predominantly has sent me emails. And most of it was mostly email, not text message that she's been sending me.
The messages that you provided as exhibits, a lot of them were text messages.
Yes.
And so,
yeah, that's what I'm telling you, Judge. As much as she texts, she emails more.
The other messages that you were receiving, I think Exhibit 1 has that big picture of all those, emails or whatever, but your testimony is that primarily she's been communicating you with by email. And tell me more about the nature of the emails that she's been sending.
Yeah, so as some of the exhibits I admitted today.
That is my question right there. I don't know.
These are just the ones that I felt, again, I know that we're here for injunction against harassment, so I was focusing on messages that pertain to harassment itself. But the rest of the messages, again, were very repetitive. I think a lot of this is encapsulated as far as what she was sending me. She would send me visual images to try to harass me. She noticed that when she sent visual images, I became emotional, and then she would send more messages on top of that to try to aggravate me. again, I was not able to submit all of the emails because I would have submitted probably 500 to 600 exhibits. And so for the sake of time, I chose what I felt was specific to harassment itself. But I would say that, again, the first exhibit that I submitted, it just shows you with the folders the dates and how often she was sending me emails. And it was just every day, or every other day for 5 months. And I believe that this individual, again, her whole, she tries to overwhelm individuals through constantly messaging and trying to convince them of this reality that she has created. But again, as I will have to go to court tomorrow with the family court, she has not been able to prove she is 5 months pregnant with twins. And I continue to reiterate that because she has falsified medical records, I believe, and she's also lied under oath. And I believe these are criminal offenses, and I believe that this individual continues to do this in court, and that is why I've tried to draw parallels with the other cases, because she's done this multiple times, and I believe that she'll continue to do it. So I am trying to, for one, stop her from communicating with me, but I'm also trying to bring to light that this individual continues to do similar repeated patterns of behavior, and it has been extremely stressful. I have been very, very, very stressed out by receiving these constant influx of messages that could have all been solved had she had just took a prenatal paternity test all the way back at the earliest time that we were able to do so. None of this had to have happened. She didn't have to take it this far. But the point is, the point I'm making is she never actually wanted to take it until I went public and stated I signed up for a prenatal paternity test. Now she needs to schedule her part. I then placed that upon her to schedule her portion, and then as people knew.
Seriously, Clayton, you got to go a law talk with Mike route and just don't read your emails. I mean, I've come to now. I'm older than you, but I've come to this conclusion long ago.
That she had to schedule it. She then scheduled, but the test came back little to no fetal DNA present, which would track with her not actually being 5 months pregnant with twins. Because if she had twins, then there would be fetal DNA present. She claims that there was an issue with the sample. She then submitted another sample that got caught up in Tennessee or wherever. It didn't make its way there. I can give my own opinion on what I believe happened, and I believe the message may have been intercepted, but I do not know that. But I know that when she tests again, it's going to come back the same thing. I do not believe, at this point, I'm not technically questioning that she's not pregnant, because I do believe she may have gotten pregnant to corroborate her story, but I 1,000% she does not believe that she's not 5 months pregnant with my twins. And that ultrasound that I have, she would not call the facility when I met with the mediator at the early resolution conference. She would not get on the phone and make a phone call to just state, did I in fact come to this facility? Because I believe she never went to that facility, and that is a falsified medical record.
All right. Anything, Mr. Lopez, do you want to present some testimony?
Yes, Your Honor. And before I present, how are we on time?
Fairly short.
How much time do we get?
I would say 20 minutes.
Okay. Could you please remind me when we're at 5 minutes? I appreciate it. Thank you, Your Honor. So, Laura, how did you first meet Clayton?
He was my realtor. I contacted his agency because they specialize in creative finance, and then I got connected with Clayton. I'm sorry, go on.
Did you become intimate with Clayton at some point?
Yes, I did.
And was it Clayton that, I guess, made you pregnant? Or is it the two of you that created these unborn children?
Yes, there's absolutely no possibility at all they are anybody else's. There's no chance.
And you're testifying under oath today, is that right?
Yes, absolutely.
Under penalty of perjury?
Yes.
Now, when did you find out that you were pregnant?
On June 1st, I found out.
Okay.
Ma'am, are you a whore?
Ever let Clayton know?
Yes, I let Clayton know on June 1st that I was pregnant.
How'd you let him know?
Well, I had gone to urgent care to get the pregnancy confirmed because I figured he wouldn't believe me. And then afterwards, I sent him a text telling him that I was pregnant.
Right there, it sounds bad to me. I figured he wouldn't believe me. It's only something spoken by someone who has such low credibility that they assume people won't believe them.
And how did he react?
He said that if he was found to be the father, that one of us would get 100% custody. He wouldn't do joint custody. He told me, or it will be put up for adoption, was what he said initially. And then he said that he might even move out of state with the children. And so I think it's understandable that I would be panicky about, what exactly he wanted done and why I was so into getting a parenting plan before they're born.
Okay, now let me just stop. This communication that you were having with Clayton, how was that communication? Through text, emails? How were you communicating with him?
Mainly through text.
And was he texting you back?
Yes, he was texting me back through about June 20th.
And prior to you becoming pregnant, was it your understanding that Clayton wanted?
I mean, not to be so explicit, but yeah, that's the one possibility where she could be pregnant based upon what he's saying, or he could just be lying and they did it and she's pregnant. I just don't believe her. I mean, I don't believe her from what I've seen. Again, if a independent or credible doctor comes out and says nope, she's pregnant and he's the father, then I'd be like, okay, I can buy this.
Wanted to have a family.
Yes, it was.
Okay. And were you doing the things that you could do to inform him about the pregnancy and what was happening with it?
Yes, I was.
Okay.
Every step of the way.
What were those things that you were doing to inform Clayton?
Well, I invited Clayton and his family to my first sonogram with, he can't deny that I wasn't pregnant. I got into a specialist, a perinatologist, because I have epilepsy. And that was my first appointment. I know we have that in evidence as well, that he was invited. I even told his family if they wanted to come that I would change the date for them.
And what month are we talking about here? What months are we in when you're talking about these different things, the communication between you and Clayton?
July, because that's when I found out I was pregnant with twins. But in June, that was when I went over to Clayton's house and took the pregnancy test in front of him.
Now, during this time when you first informed Clayton, was it clear to you whether Clayton believed that you were pregnant, or did he not believe you, or what was that conversation?
I know that what he wrote initially was basically that he believed it, and because that's why he got into the custody stuff. But really, throughout this whole thing, I would say the theme has definitely been that he doesn't believe I'm pregnant, and I believe that's because he just doesn't want to take responsibility.
Okay. Now,
yeah, he doesn't want to take responsibility for a baby that he didn't make.
You indicated there was a time that you went to his house. What was that in regard to?
I went to his house because he invited me over on, I believe it was June 17th. He invited me over saying he wanted to talk, and I agreed to go over to his house. And once I got there, I told him I would love to order a pregnancy test, and he said he already had one. So then I took the pregnancy test in front of him. I peed on the stick in front of him. It showed up positive pretty much right away, and he just threw away the stick and said he didn't need to see more. And then we talked about what would happen for us down the line, and he said he would, consider figuring out dating or whatever, because I don't think it's unreasonable to want to see if things can work with the father of your, what I now know as kids.
And let me just stop you. Now, were Clayton's intentions regarding the pregnancy and the unborn children ever clear at any point as far as what he wanted to do?
No.
Okay.
No,
so there was one, and when we say over, so is this over weeks or even months that we're talking?
Yes. Yes,
okay.
over months.
Okay. So was there a point when he wanted you to have an abortion?
Yes, there was.
Was there a point where he wanted to give the kids away for adoption?
Yes, there was, and all of that's in text messages.
Okay. Was there a point where then he didn't want anything to do with the kids and you have sole custody?
Yes.
Okay. And these are communications that you're having with Mr. Echard through text messages?
Yeah, those were through text.
What about emails?
Emails started later on, after we had the day after we had the conversation where I went to his house and took the pregnancy test. He and I were having a good conversation. Like, he messaged me in the morning. He said he wanted to be intimate that weekend, which I also have that text. And then an hour later, without me responding, he said God told him that we were not meant to be together, and he took that back. And then he blocked me, and I've pretty much been blocked since then.
Okay, so you would admit
he wanted to be intimate that weekend. Nobody says that. I mean, I don't know if she's cleaning up for court, so I'm not going to knock her, but it's just hard for me to buy. And then she says his next text is God said we shouldn't be together. Could there be a bigger indictment of your initial, BJ? I mean, seriously.
that you knew that Clayton had blocked you at some point. Is that right?
Yes, via text. Yes, I did.
Okay.
And he
But
told
then
me
would there be...
that
Go
was
ahead.
that's what I want to say is he told me to email him.
Okay. But were there times that even after he blocked you, he would then communicate with you through text?
Yes. He'd
Okay.
block and unblock.
So sometimes he would block you, but then he would unblock you?
Yes, and I think if you go to Exhibit 1, you can see some of the text messages that he sent to me.
Okay, let's take a look at Defense Exhibit 1, Your Honor, if I may. What is Exhibit 1, Your
Okay, well, it's not Exhibit 1 because obviously we have all of the plaintiff's exhibits. So you need to refer to the exhibit as it is on the exhibit worksheet, which I'm assuming the first defense exhibit I have is 40.
Okay, Defense Exhibit 40.
I was only given 37, 38, 39. I don't see any other exhibits.
Titled Clayton, cruel and threatening text to me.
Your Honor, those are the exhibits that we had uploaded to the court, but I don't...
Were they provided to Mr. Echard?
I gave them to him on a flash drive right before the hearing.
Okay.
I did upload them, and it said it was successful. And that was on Friday or Thursday.
Okay, Ms. Owens, thank you. The court has the exhibits. My issue is that Mr. Echard doesn't have the exhibit. So I guess, Mr.
I could show them on my computer, Your Honor.
How we believe that he would be able to view those.
Well, I have them on my computer, Your Honor. I gave him a USB with the exhibits on it prior to this hearing.
Okay. I mean, prior to the hearing, like when you came into court today.
Yeah, I gave him the exhibits on a thumb drive. We had submitted the exhibits as the court wanted. I gave them to him electronically on a thumb drive, and I have them on my computer. I don't have them printed out.
Well, I guess I'm not sure how we're going to...
I have them right here on my computer. I will.
I mean, I understand, but you're just going to show him them on your computer while you're talking about them? Is that what you're trying to do?
I'll let him access them with my computer, yeah.
Okay.
They're all in order. If you're saying it's Exhibit 40, then I guess we'll start there.
Okay, Mr. Echard?
I was just going to say, I mean, yeah, he gave me a thumb drive 20 minutes before we started this case, so I don't have my laptop with me. Nothing was submitted to me until today. I don't understand how, then I don't have any of it, so how can we bring it to light when it was never sent to me until 20 minutes before the case? And I don't have a computer to plug the flash drive into.
Yeah, and if I may, there are no disclosure requirements in these types of cases. The rules of protective order procedure, injunction against harassment, there are no there are no disclosure requirements. Despite that, again, I gave him a flash drive before court today. I have the exhibits on my computer. He has access to them.
Okay. Well, the logistics of that seem extremely difficult to me when we're at 4:30 already. So we're already an hour and a half into the hearing. And so if we're starting to look at exhibits on your computer while you're trying to ask questions of her about them, I find that's going to be a bit of a difficult issue that I'm having with us trying to logistically all do that.
What does the court propose?
I mean,
again, I can show him
that your exhibits don't get admitted. That's what I'm proposing. This is unbelievable.
Computer. The exhibits are here. I have them in order.
I almost think we need to reset for another, half hour of hearing where you can provide the exhibits, or he can have an opportunity to at least view the ones that you provided on your flash drive, and then we can discuss them as we're trying to admit those.
I mean, we could do that, Your Honor, but then I'd like to proceed with the rest of the case, just to use up this time, and then we could do that at another time if we need to.
I mean, that's fine. I'm just saying I think that exhibit issue, we need to try to resolve that. But if you have additional questions you want to ask her, that's fine.
Okay. So was there a conversation between you? Clayton was responding back to text messages that you had with him, correct?
Correct.
Okay. And same thing with emails during this time?
Yes, yeah. It wasn't like he stopped responding. And I also do have on MailTrack that Clayton opened to every single one of the emails. I know he said he didn't, but I have proof he opened to everyone.
Okay.
Oh, that's the most psycho thing I've ever heard. She's just sitting there waiting to see if he opened it or not. Oh, God. Run, men, run. I'm not saying you're all like this, ladies. I'm not. So I don't want to hear it. I don't want to hear the pearl clutching. But men, run like hell.
And the different exhibits that Clayton had admitted into evidence during his
because we don't know which ones are and which ones aren't.
Case, those were not the full text message conversations or emails between you and Clayton. Is that right?
Yes, that's right.
Okay. He was, in fact, texting you back and emailing you back.
Yes, that's correct.
And during the entire 5 months, or since I believe it's May that's indicated in the petition, has there been one time that Clayton has told you, please stop texting me, please stop emailing me, or something along those lines?
No.
Thank you. It doesn't work for anybody. I agree. Everyone, social distance, at least 100 yards between you and anyone else at all times.
In fact, you had asked Clayton whether it was okay if you went to the media regarding this. Is that right?
Correct.
And what did he say?
He said, if you can...
Yeah, you only share exhibits if you want to admit them into evidence, which is the whole point. Generally speaking, I don't know. The attorney's saying something, and this might be the case, because this is some sort of PPO, emergency procedure or something. Maybe it's lax, but I'll tell you, in my practice, if you just didn't provide exhibits, you're done. You're done. You have to provide exhibits. If it's real small and it's like something simple, you just bring copies and you can hand it to them before you show the exhibit to the witness. But if you've got like a list of stuff and it's complex, especially if it's videos or something like that, no, you can't expect someone to review that in court.
I'm completely unbothered by it. And I went to the media the next day, and I never wanted to go to the media. I just wanted to make a parenting plan.
Okay. Was there a time that you had to hire an attorney?
Yes.
And what was that in regard to?
I thought it would be easier for the two of us to communicate to try to get that parenting plan with an attorney and for us to avoid having to go to court.
Okay. Was there a time that you tried to do paternity testing with Clayton?
Yes, absolutely. Clayton was very unresponsive to that. and I paid $750 in August to have the testing. I asked him to email the lab to schedule his time because I already had a time scheduled, and he never emailed the lab, so that's why it was canceled. He had, more than a week to email the lab to tell them a date and time, and he didn't do that.
How many times did you schedule paternity testing?
I paid for it once, but I was in communication with the lab, RavGen, which is the lab that Clayton shows, about scheduling countless times.
Okay. And did he ever do any paternity testing, or did you do any paternity testing?
Not until recently.
Okay. And during this, you and Clayton were texting or emailing back and forth regarding scheduling of the paternity testing?
Yes, exactly. And I didn't really have to provide prenatal paternity testing by the court. I was doing it for Clayton's sake. I could have waited until they're born.
Okay. And was that the main form of communication between you and Clayton?
100%. Everything was about paternity and pregnancy. That was it.
But was it through emails and text messages?
Correct.
That's how the two of you decided to communicate?
What was that?
That's how the two of you decided to communicate?
Yes, was primarily through email.
You said something, except for something.
Oh, except for in June when we met up. Other than that, it was just by texting and emailing.
All right. And it came to a point where Clayton wasn't agreeing to, or he didn't want to create a family plan. Was that your understanding?
Yes, that was.
And what did you want from Clayton?
I wanted to create a parenting plan because I was so unsure about, since he'd given me so many different options for what was going to happen. I really wanted it nailed down before I give birth as to what custody was going to be. And I wanted to see if there would be a possibility for us to do joint custody, not to be dating, but just because I think that would be the best thing for the kids, to not have 100% and 100%, or just 100%, I'm sorry.
Okay. And that wasn't possible to do prior to hiring an attorney and then eventually filing a family law court case. Is that right?
Yes, that's right.
But you tried to make that happen. Is that right?
That's right. Yes. That was the
And
whole point.
that was the point of the communication.
Hello.
Hey, how's it going?
Look who's here.
Oh, look who the cat dragged in. Oh, man.
So you were off doing some Toys for Tots thing or something?
Yeah, it was just raising we do a little single mom Christmas gift kind of giveaway. So yeah, we just did that on my live stream.
That doesn't line up with the animal that you're supposed to be.
Well, hey, our community is super giving, but not everyone makes it to the nice list this year,
Apparently not. All right, we only have a few minutes left. I was surprised because I just got sent this a while back. Apparently it's been out there, but I just became aware of it.
Boy, yeah. You know what? Now that you're covering this case, it's like the movie Exorcist, where they throw the holy water. You're the holy water that's making this go crazy. I don't know what it is about you. Maybe it's the Chicago accent, but you're really ruffling some feathers out there.
Well, we pulled it into LawTube. We'll see. But that, I was interested because she has this bump, right? And she stands up, and I'm like, I'm not buying it, but I don't want to say it because everyone's always like, you don't believe any women and blah, 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 blah. So I'm like, I'm not even going to say anything. My chat's not buying this baby bump.
Hey, everyone can have their opinion, right? I mean, some of these bumps, these prosthetics will go only to the sleeve, and some will go down, like they go in different areas, I guess. And when you use them for film and TV, you have to just know if you're going to be using a prosthetic, how to position it so it looks real. But I think the whole time she's standing, now my wife's pregnant, she stands as little as possible. But I think this whole court case, she's standing up at the desk, and which is kind of like confusing. Then the part 2 that you watched last week was a tight shot on the face. So this one, it's like very much, but you have to remember this court case They didn't know this was being live streamed to the audience. They thought they were in like a closed court, as far as I'm concerned. I think that's what their belief was. So it was almost like they wanted the courtroom to see the belly, but not the public scrutiny. You know what I mean?
Yeah. Oh yeah. And the other thing, which in the second part about my first hearing that I saw, I didn't really see Clayton talk. He was there and he wasn't saying anything, and that was appropriate because she was testifying.
Right.
So, but he talks and he does this thing. First of all, he's representing himself. Honestly, he's doing a really good job. He's struck me as a very reasonable guy.
Oh yeah, I don't think he was prepared for like objections and those things that like a layman wouldn't understand, but he just went in it with a lot of naive hope. And after watching this video you're watching, that's when we set up the GoFundMe for him, just to be like, dude, you got to get some counsel and like let them give you a fighting shot here, because it just kind of felt like he wasn't necessarily, he
certainly doesn't know procedure.
Right.
But even that, he strikes me as a very intelligent guy. He didn't try to BS about it. For like, it was sort of charming. He's like, he basically said, "Judge, can I do a closing argument now?" And she's like, "No, it's not time. We have to have a testimony from the other side."
He's like, "I watched Law and Order. I thought I'd do my closing testimony now." Yeah.
But then he's like, okay. And then, he gets some of those things confused. But in terms of the logic and his demeanor, he was very reasonable.
Right. Like, how would you rate him just from a credibility standpoint, as far as like how he comes off? I know, he
struck me as very credible. The one thing is but although I have explanations for this, but I think their best point is when they say that he was suggesting an abortion or this, that, whatever he was doing, that was responding to this as if it was a baby.
Right.
That's the strongest point she has. However, I can explain that in a lot of ways. I'm not going to right now, but I can explain that. But that to me is their strongest suggestion, that he thinks there's a baby.
Right.
I don't believe that he thinks there's a baby overall. I really don't. But I think that's the strongest argument they have.
I actually thought this was a good use of, if he was being gaslighted, that this is what it would look like. A guy that says, like, we didn't even have sex, but I guess maybe something. Like, to me, it came off as a very naive guy who couldn't fathom somebody potentially lying to him. And so he's trying to wrap his head around it. But I think he kind of like came out of that spell and then realized, no, this isn't true. And then once he started getting the test results in, he was kind of like, all right, I'm being duped.
Yeah.
Once he heard of the previous case.
Look, when this happens, you might have had a few cocktails, and your mind goes to things like maybe a turkey baster was used, so you're sitting there thinking, I don't think so, but who knows?
Yeah. I mean, it sounds crazy as an outsider to say, but when you're panicking and you're like, you just can't imagine a scenario in which the other person's like completely lying to you.
Or yes, or you could just actually, like, okay, in a conversation, you may just indulge their delusion and say, okay, I don't think that's the case, but to the extent that's the case, then why don't you do this?
Right.
And what you're suggesting is adoption or abortion, is what you're suggesting is, I don't want you.
Yeah.
So I don't know. We'll see. All right, let's finish it up here, shall we?
Via text message and emails, is that right?
That was entirely the point.
Okay. When did you file the family law case?
I believe it was August 1st.
And was there a point in time that you had to meet up with Clayton because of that case?
The opposition.
Yes.
And what did you need to do before that hearing?
Well, there were two things. I filed a motion where we were supposed to have a good faith consultation, and Clayton just didn't get back to me about that. And then we were supposed to get together before the early resolution conference to see if we could resolve the issues or resolve some of the issues without having to involve the court, I guess.
Is that, and when you received that information from the court regarding those things you needed to do before court, was it your understanding that you were supposed to meet up physically?
Yes, it absolutely was. It specifically said meet up, and he got the same information that I did.
Okay, so you were trying to meet up with him physically due to what the court had ordered.
Correct.
And you communicated that through text messages and emails.
Correct.
Okay. Now, did that meeting ever happen?
No, it did not.
Okay. Who was trying to make it happen?
I was the whole time.
Now, did you know what the penalty would be if you didn't meet up?
I was just going to say that I did not know what the penalty would be if we didn't meet up, and I didn't want to face any penalties or get in trouble with the court when I was trying to abide by the rules. Yeah, that was all I was trying to do.
And the family court case between you and Clayton, that's still active, right?
Correct.
You guys are both unrepresented, is that right?
Yeah, correct.
So you're forced to communicate with him regarding some of these issues, at least, is that right?
Yes, absolutely.
Scheduling and
It's a good question.
meeting
I don't
for
know.
things like that.
Yeah.
Now, there was a paternity test that was done, is that right?
Correct.
Okay, can you tell me a little bit about that?
Yeah, so I took the paternity test on I don't know, it was earlier this month, I believe. And it came back within the sample, there was little to no fetal DNA, which I was told specifically by the guy who heads this lab that the testing was ongoing, that was not a conclusive test, and that he needed to have me do a retest. But after that, I said, is Clayton aware of this, that the testing results are not final? And he said yes, and I do have that as an exhibit of him on the phone telling me that. But despite that, Clayton went public and said, we also have that exhibit as well, where Clayton boisterously said that there was little to no fetal DNA and I wasn't pregnant, which incited a tremendous amount of harassment towards me. And then after the
All right, I have to go back to this right now, though.
She thinks that people cross-examining her is harassment.
Yeah.
No fetal DNA. I called RavGen. They say they can provide fetal DNA as early as 5 weeks, but definitely by 8 weeks. And since this court case, guess what's on here? My little recorder. Them telling for the second time that there's no fetal DNA. So maybe there is fetal DNA, but it's hiding behind the Monster Energy drink she's crushing.
Is that you talking to them about this test? But I saw a video on your channel that there was another test.
Right. So I believe that test 2 ended up getting stuck in transit and they weren't able to test it in time. Test 3 came back to little to no fetal DNA. They want another test to confirm again, but they can't say no DNA, right? It's like, it's part of like science. They can only say little to no because that company's not set up to test whether or not you're pregnant. It's to test who the father is. And it's my belief, again, just an opinion, that it could be that she was claiming to have twins because it was up until recently, you couldn't do a prenatal DNA test or a paternity test on twins. And I think Clayton had to find a place that could actually do it. And they have like groundbreaking technology, but you know, they go there, they're the ones who conduct the test. It's not like a administered test. And this is the second time where it came back to little to no DNA. It's a professional, you would think if something was wrong with the testing, they would say it's inconclusive, but they did say that it means there is no DNA that they've been able to find. So that's just where it stands.
Right.
So you can't get mad at people.
If we're scoring at home. All right. Three tests. Number 1, little to no fetal DNA. Number 2, lost in the ether.
Yeah.
Number 3, little to no fetal DNA.
Yeah, so someone's going to get their Christmas package and they're going to open up a DNA test. Hey, Mom, I didn't get any fetal DNA.
It's the missing Echard fetal DNA scenario. Yeah. All right.
So let me stop you really quick.
Oh, sorry.
Stop you really quick. Now, during the paternity testing, did you have to communicate back and forth with Clayton regarding results or what was going on?
I tried to, and he would not respond to me about it.
And is that when he went online?
What was that?
And is that when he went online to indicate what the results were?
Yes. Yeah, and that's what.
There were no results?
Yeah, there were no results. Testing was ongoing.
Is it still ongoing?
Yes, it is still ongoing. They just needed a sample that wasn't so diluted. And so they asked me to come back. I took a test a couple weeks ago. I think it's crazy that Clayton's acting like I somehow intercepted that sample in Tennessee. It ended up, I guess, getting stuck in Tennessee and getting delivered in 2 days instead of 1 to the lab, which meant the sample was no good. And then I went today and I gave blood again. But that's my 3rd time giving blood. It's not my fault, at all.
Now, aside from texting or emailing Clayton regarding the pregnancy, the paternity test, this family court case, was there anything else that you had emailed or texted Clayton?
Not a single thing, and he knows that as well.
What about the posts online?
Well, that was related to the paternity. I did message him after asking him to take that off when I started getting people telling me to kill myself. And people were posting terrible reviews on my podcast. I was getting horrible messages on my Instagram. I had to deactivate that. And I begged him, please take this down. The results are not back. Here's Brett from Ravgen explain.
Okay, I've never seen 1 minute of it, but is it possible that her podcast just sucks? I'm thinking that's a possibility.
Look, I don't know. Yeah, I haven't subjected myself to that. I'm too busy catching up on my Bigfoot podcast that I like to listen to.
I did about 12 seconds of her TED Talk, and that was enough for me.
Well, that's
that
I was going to say, I made a joke with you last time, and she's already threatening to sue me for defamation over it. The whole joke about wishing she was on the Malaysian flight that disappeared.
God!
That literally made it to my lawyer the next morning. I was like, "Well, hey, Law Mike, you got 1 more viewer now."
I didn't even look, but she, in her email to me, she was very upset that I released her name. I literally don't know, but I don't think I said her name.
I certainly haven't.
And I play like a very small snippet of her TED Talk, which appropriately has her captioned as the speaker, and then she introduces herself.
Yeah. Hey, no publicity is good publicity, I guess.
From a woman who testified right here that she had to go to the press with all this, but she doesn't want anyone to know her name.
Her game plan is to privately tell people not to talk about it, threaten to sue them, and then she gets away with it. So finally, she's being held accountable. She's being cross-examined. If she's going to have a baby, fine. It's just the science hasn't shown that so far.
Yeah. I'm willing to, I don't believe her as we sit here. I'm willing to change my mind if the right evidence is produced.
Smart man.
Frankly, if the court believes it, I believe it. I'll use them as my proxy.
Sure.
That's simple.
Know that the test results aren't back. You can't be posting this kind of stuff and inciting harassment against me.
And is that because you're understanding Clayton's fans or Clayton's followers were harassing you online?
Yes, and they were naming me in his comments and giving my my handle out, my Instagram handle out.
Okay, and those were because of Clayton's posts?
Entirely because of Clayton's post. And then on Reddit, I mean, I can't even go into the what people have said about me on Reddit as a result of his post, which I mean, I'm clearly pregnant.
Reddit is a cesspool. I will say that.
And I, will do anything to prove the paternity. And so it's just all of this information that he's put out there that's false has been so upsetting to me.
But you had reached out to Clayton regarding those posts and asked him to take it down after you were receiving these harassing emails or messages online?
Correct.
Okay. Now, was there a time that you had reached out to somebody who Clayton was going to speak, somewhere where he was going to speak?
Yes, I did.
And what was that?
5 minutes.
And what was that?
I contacted them because I was feeling suicidal as a result of Clayton's action towards me. And
there we go, crazy. Don't worry about it. Reddit hates me too.
Sure, I'm hormonal because of the pregnancy and not knowing, what the plan is going to be going forward. But I felt that it's strongly in my heart. This was not to harass Clayton. I just felt that if Clayton was the kind of person who would not respond to me knowing I was pregnant with his kids, then there's no way Clayton would respond to somebody else who reached out to him saying they were in need and that they were suicidal.
Okay, let me just stop you. We have about 3 minutes.
Okay.
So, Clayton had brought up instances of other cases that you're involved with other individuals. Is the current case that you're involved with Clayton with similar to any of the other cases that he's brought up in his exhibit?
No.
Okay. And that's an ongoing case, is that right?
Correct. It's been going on for 2 years, and that attorney dropped out of the case. There was never an ultrasound presented to him. I was too early on, but the pregnancy was proven to him by a nurse practitioner, by tons of medical results. I can prove that all day long.
Now, in the communication that you had with Clayton, were you ever trying to threaten him or harass him or annoy him in any way?
Absolutely not. Absolutely not. I mean, I would think he would want a parenting plan as well.
Okay. Your intent during this time was essentially to get the parenting plan then and get this all figured out before the unborn children are born.
Yes, because I'm panicked about having twins and not knowing if he's even gonna, he specifically put on that he didn't want to even be on the birth certificate and didn't want to give them his last name. So.
No further questions, Your Honor.
All right. So I'll go ahead and stop here, and then we'll pick up, because you may have some questions still for her about the exhibits. If we're going to pick up again, I'm assuming that there may be some exhibits that you want to.
Oh, yeah. When I said no further questions, I just meant.
Yeah, for now. Yeah, no, I understood. That's why.
Okay, so nothing else happens here?
We're going to take a break now, and then, Mr. Echard, you have the exhibits now in your possession. Is that?
Yeah, enough of that.
So
all right, everybody.
Yeah, just watching that was like, just get him some legal help. She says that the last attorney, the other case she's in with Greg, she said the attorney dropped out, and she says that as if to say clearly he wasn't believed. Wait till you find out why that attorney dropped out. I don't even want to share it here, but there's other videos about emails that were sent from her to the judge that were crazy accusations. And
how come I don't have these other videos?
They're the same person's got them all. I'll get them over to you, but it's all those documents are online that show the email that she sent out, thinking that this guy Greg and his lawyer were conspiring in some sort of wild accusations. And I think my guess is that lawyer was like, I was already doing this on the cheap. I don't need this in my life, and bounced. Yeah.
Oh Lord.
Now, little does she know.
Is it Schnitzel Ninja?
I believe so. But
big shout out to Schnitzel Ninja. Give them some love, but more to the point.
Well,
I just posted Schnitzel Ninja's video, but Dave showed up. Everybody go over there and like and subscribe. Give Dave some love. He's had updates on this thing too. I can't keep up with him.
Yeah, I'm scheduled for court on Monday. That'll be the harassment case she has against me. But what she doesn't know, and the time here is because they tried to give Clayton that last minute evidence, it made the court delayed 10 days. That got us enough money to get him a lawyer. He hires the other guy's former attorney. So a guy who had, all of the knowledge going in, and then Clayton wins that case. So,
yeah, and that attorney was excellent.
Yeah, they did a great job.
That firm knew what was going on.
They knew what they were doing. And then the other case that she was involved with has been dismissed. Her injunction, or her she was suing for $40,000 for emotional distress. That was dismissed. And as of right now, I think I'm the last one that she's got something with for now. But she's threatening me every single day with defamation suits. She wrote an article about me saying she published emotional blackmail where she says that and this is true. She emailed me saying, if I hurt myself, the blood is on your hands.
Yeah,
those are her words.
That's manipulative, nasty stuff.
I never reported that. I was like, I don't even want anything to put that out there. But these are the types of emails that I'm getting on the daily.
Oh man. So you're actually up in court. Is it Zoom, or do you actually have to walk over there?
I'll be over there. Yeah. I'm going to take my bird scooter. I live pretty close by.
Where is this? I don't even know. Is this in Arizona, Maricopa County?
No, this is in LA Superior Court. So this is
LA Superior Court.
I believe so. Yeah. My unless it gets delayed again, it's on Monday. I don't know if she's going to attend.
Oh, I got to hear about this.
She threatened to file a harassment suit against me in Maricopa, and I haven't heard back about that one, but it's just nonstop on the edges of my on my seat, waiting to see where she's sending me. But I'm just trying to share the evidence and help.
And you have an attorney representing you?
Yes, I've had a GoFundMe set up by an audience member, and we had a nice big. Yeah.
Is your attorney striking out that you ever talk about this? Am I getting you in trouble here?
No, they know I'm coming on here, and they're
they're good. They're okay with a lot of talk with Mike.
They like that I'm sharing the truth, and I think you can't. I don't have to hide behind it.
They're hyperventilating at home right now.
My belly's real. This is a Thanksgiving belly here. This is your holiday seasonal. No prosthetic belly.
All right. Well, thank you for coming by and adding context. Here's the thing, because I don't know anything. I just start watching them, right? But then you know all this stuff and add to it, which is really nice. Yeah. Now I got to hear what's going on. But I owe you an appearance. I need to come over to your channel and slap around and make a mess.
Anytime. I appreciate it.
All right. Thank you for coming by. I appreciate it. We did 2 hours of this thing. I can't believe it. We did the whole thing.
Oh man, get a good sleep after that one.
You're not gonna. There's not gonna be a video of that thing, right?
Of my case?
Of your case?
I don't know. I'm
I don't ever see that in LA.
Yeah, I don't think so. But
you can't do it.
I know, but I will. I'm gonna have my camera right after. I'll be on the court steps to make a live update. So
that makes sense.
If they allow me,
people always ask me this stuff like about my cases. I'm like, that's like the only place I can't go anywhere. Because then I got a judge directly over me and a client and respond all this stuff. I can talk about any other cases, but not mine.
Yeah, it's tough. I mean, I don't know too much about the system. I don't have a law degree. I'm just, they struck down the temporary restraining order over First Amendment rights, and she's, claiming all these things. And I've never said her name or showed her image. I'm just trying to help these guys out who want a fair fight because,
By the way, you can though.
I know I can. I'm just for the record.
Nobody on the planet can say no one can speak my name.
Right.
Well, I'm Voldemort. You can't do that.
No, it just makes me vomit, so I try not to. That's the only reason. It's for my own, to keep my dinner down. But yeah, no, I've said this before. I would raise a GoFundMe in a second to get her some mental health help if she was seeking it. It's just she's been enabled, in my opinion, to let these things carry out in the darkness of these private court cases. She wanted all this sealed. It's out in the open. Let's stop it already.
Oh, absolutely. I could flip to supportive real quick.
Yeah.
But yet you've got to accept reality first.
I got to support Clayton first. You know what I mean? Right. I got to help him out. He's had a hell of a bunch of gigs canceled and no one believed him at first. What she has to remember, she goes, oh, everyone's out to get me. Everybody believed her. Everybody gave her the benefit of the doubt. And then the cracks came in. People saw the unredacted email that said Clayton said, hey, we only had oral sex. All of that happened.
And then I see a lot of stuff, and people don't mean anything by this, but I see people like, oh, he was an NFL player and he was on The Bachelor. I'm like, you know what? I those things don't make you rich. He didn't really play in the NFL. He was on a team. It's damn good. He was a walk-on. He's an excellent football player. I don't mean it to demean him, but he did not have a big NFL contract to make a bunch of money.
No, he couldn't afford a lawyer right there. That's where he was.
And then he seems like a bright guy. He's had some neat experiences, but he's not necessarily a wealthy man.
No. I mean, I think he just bought an Airbnb and it opens in the spring. So he's trying to get it going. So there's no cash coming in. And he was like, oh, I just handle it on my own. And I was like, no, man, take care of this right now.
He's got a bright future. He'll probably get there, but I don't see where he's necessarily wealthy. He didn't win the lotto or something.
No, 2 weeks, two practice squad checks, probably made 10 grand, paid half in taxes. Yeah. And he, some goes to the agent who signed him. And then that was 5 years.
I have zero idea what you get paid to be in The Bachelor, but I don't think it's a lot. You get a lot of notoriety. You get a lot of sort of secondary benefits, but I don't think they're saying, okay, here's $1 million contract to show up.
I mean, the lead gets paid probably 100,000, 100 to 150, but that you get half of that after all of the fees. And then, you're also can't have a job, you do that.
Right. And you're busy doing that. So it's like,
Yeah,
you know,
spend half that in suits and then paternity tests. But I do believe that Ravgen refunded him for the last test he took. Even they're saying, "Hey, we're sorry you're going through this." And I think they're trying to help him out here. But hey, look, I reported it that the latest test was little to no fetal DNA. Immediately, she writes the article trying to slam me. My guess is she finally went public with that Medium article because of you and a few others posting on YouTube that finally started to have her name in the court. Because I blurred it all out because I didn't want anything to do with it. But I think she's finally trying to take the victim stance publicly, and I'm just like, I'm not having it. No, I've never said her name. I've never drawn any attention to send her hate. It's all like it's a pro Clayton case. That's where I want to put my energy. And if someone else wants to send her a DM, it's not under my sort of recommendation. Or you can't control the internet from these stupid death threats that come. Like everyone gets death threats. I get them walking out the door. Like the internet's crazy.
Oh, believe me. Yeah. Believe me, I know all about it. All right. Thank you for coming by. I really appreciate it.
Anytime.
Say the channel name again one more time, though, because it's Dave Neal. I have Dave Neal Comedian, but I can't remember the rest. Because
well, you can just search Dave Neal on YouTube, and my podcast is morning and afternoon. It's called Bachelor Rush Hour. I cover entertainment news every morning and afternoon.
When you say podcast, is that on YouTube or is that a different? Is that a different platform?
That's just on audio on anywhere, Spotify, Apple Podcasts, wherever you listen. So you can find my YouTube videos, and then you can also find Bachelor Rush Hour.
That's awesome. Thank you for coming by.
Thanks a lot.
Good night, everybody. Thanks a lot.